Let's now look into general principles of law, unilateral acts, acts of international organizations, and soft law. So here you can see I have listed 3 sources with a blue symbol, which are the proper binding sources of international law, and a green symbol for what we call soft law, and finally the complementary sources of international law, which are used mainly for interpretation and to reinforce arguments, but not as independent sources of international law. As always, a reminder here of Article 38 of the Statute of the International Court of Justice. As I have said several times, this is not an article that's binding for all the states as such, but it is considered as listing the most commonly accepted rules of international law, or sources of international law, mainly treaties, customary law, general principles of international law. Judicial decisions and the writings of jurists are also listed there as complementary sources, but not proper sources of international law. They are not listed under Article 38 of the Statute of the International Court of Justice, what we call unilateral acts of states, and also acts of international organizations. Both unilateral acts of states and acts of international organizations can produce rules that are compulsory, that are binding for states. Those that are under the category acts of international organizations are normally considered as belonging to treaties, because the power of international organizations to produce binding rules is derived from a treaty, normally the treaty that serves as the foundational charter of the organization. General principles of international law are a very vague category that's difficult to define, but they are also mainly reduced to a maxim or a simple concept that serves as principle of interpretation to resolve conflicts between regulations, or to fill lacunas, gaps in international regulations. Although they are many times found in many other domestic law regimes, they are not only, or they are not always the same at international level and domestic level. Sometimes general principles of law have been borrowed from domestic legislation, and sometimes it's the other way around, and some of the general principles of law that are applicable and applied at domestic level have their origin at international level. It is going to become clearer, I hope, with illustrating what general principles of international law are using examples. So, for instance, it is a general principle of international law that if you cause a damage, the injured state has a right to reparation. This was clearly established already by the Permanent Court of International Justice, which is a predecessor to the International Court of Justice, in the Chorzo factory case in 1928. Also, the International Court of Justice has established that it is a general principle of international law that circumstantial evidence can be admitted before international courts. Within the category of principles of international law, we also find the one of res judicata, or the principle by which you cannot adjudicate twice the same matter between the same parties. Another general principle of international law that actually informs what we will look at later, which is unilateral acts of states, is estoppel. It's a very technical principle and that has appeared several times in the jurisprudence of the International Court of Justice and other adjudicatory bodies, but basically it tries to protect the expectations of other states that are based on your own behavior. So in a way, you are expected to be consistent with your own behavior and to protect the expectations you create with such a behavior. Other examples of general principles of international law is the principle that by which you should comply with the agreements you enter in Latin pacta sunt servanda, and the general principle of good faith. I have reproduced there a passage of the International Court of Justice elaborating a bit more on that principle. One of the characteristics of general principles of law, as I have said, is that many times they are incredibly vague and abstract. This is probably illustrated the best with the principle of law that refers to equity and equitable solutions. We find many times both in the case law of international bodies and in international treaties a reference to this principle of equity. So for instance, when we study international law of the sea, we will see that the main treaty in this domain, the United Nations Convention on the Law of the Sea, calls states to resolve problems of boundaries and delimitation of maritime zones by finding an equitable solution. As we will see, the decisions over what is an equitable solution are marked by different elements, and at the end, the principle of equity always needs to be interpreted itself. Let's move now to another category of sources of international law that is not included in the list of Article 38 of the Statute of the International Court of Justice. Actually, some authors will say this is not a different category and is just another form of customary law or just an interpretation or an application of the principle of estoppel and the expectation that you will behave in a way that is consistent. The main case relating to unilateral acts of states as source of law is the nuclear test case, where Australia brought France before the International Court of Justice because it considered that France had acted illegally when it decided to perform nuclear tests in its territory in the Asian Pacific Ocean. On this occasion, France had previously promised at the highest level that they will not perform more nuclear tests, but then they didn't follow that promise, and after the promise they still went ahead. The International Court of Justice on that occasion considered that France had violated international law because it had failed to honor a unilateral act. So on that occasion, the International Court of Justice decided that unilateral acts are sources of obligations, and that something like a promise that a state can do to others at international level is clearly not a treaty. It doesn't meet the requirements of a customary rule, but still can create obligations for the state that is making that promise, if you want. It is a bit of a difficult concept because there are many times when states will make unilateral declarations that will have no legal effect, or that will have only an effect within a particular normative framework. So, for instance, when states enter reservations or declarations to a treaty, that's a unilateral act that will have the legal effects that are linked to reservations and declarations, either in that treaty or more broadly in international law. Other examples of unilateral acts that may not produce any legal effect, or with legal effects that are not autonomous, that are not produced by themselves, is the act of recognizing other states or governments, or, for instance, declarations of independence. These are all unilateral declarations that don't produce any rights or any obligations on others. In general, unilateral acts can only create rights on third parties, not obligations. So France can promise not to perform more nuclear tests, but cannot create an obligation on another country to that effect, only on themselves. Another state can expect that France or other countries will honor that promise. I am providing here another example of a possible unilateral act with possible legal effects and consequences. Well, now it is not relevant anymore, but it was at the time. After the UK voted to leave the European Union, one of the issues that arose was whether or not the UK had to continue to contribute financially to the European Union. Was there an obligation to continue to contribute financially? This question was put forward to the House of Lords, and the House of Lords answered on 4th March 2017 that the UK was allowed to leave the EU without being liable for outstanding financial obligations. Nonetheless, a few months later in Florence, before the UK had signed any agreement with the UK, the then Prime Minister Theresa May promised to honor these obligations. To me, this is a clear promise made by the person who is authorized, who has competence, who can bind the UK to this kind of obligations, the Prime Minister, towards the European Union, and this could be constructed as a unilateral act that was already compelling the United Kingdom to comply with the financial contributions, even if no formal treaty was signed to that effect. Here is another example taken from a case of the International Court of Justice. This time is a case between Chile and Peru. On that occasion, one of the legal issues was whether or not Peru was bound by rules that are contained in the United Nations Convention on the Law of the Sea, and Peru unilaterally declared that it considered itself bound by these obligations, creating like that, and this was the basis on which the court then decided, among others. Let's move now to another category of sources, acts of international organizations. International organizations may or may not have powers to create rules that are binding for their state's members. You need to look every time at the specific powers of that specific organization to answer that question. In any case, international organizations are a place where governments come together and express their positions on a wide range of issues, and when they express their positions, they are also providing evidence of what they believe the law is. So what happens within international organizations is many times a very valuable source of evidence of opinio juris, to know what the state's position is on a particular legal issue. As I said earlier, while they are not mentioned as such under Article 38, finally the power to create or not binding rules comes from a treaty, normally the treaty that creates international organizations. So you can consider acts of international organizations part of treaty law. However, many of the decisions, of the resolutions, of the statements that come out of international organizations are not binding by themselves, but are nonetheless, as I said, relevant to tease out, to understand what is the position of a state in a particular issue. So if there is a vote on a resolution, for instance, on death penalty and abolition of death penalty, which happens often within the General Assembly of the United Nations, where all the states of the world are represented, you will have a clear picture of what is the position of the majority of the states, which ones are in favor, which ones are against, and this can also serve as evidence of the emergence of a new customary law or the consolidation of an old customary rule. Obviously, many of these decisions are voted, and when they are voted, you get a clearer picture, but it is also very normal practice at international level to reach decisions by what we call consensus, which means that they are approved if nobody votes against. And obviously, not voting against doesn't mean that you are in favor, because many resolutions are adopted by consensus. Is not possible to derive, to infer customary law or evidence of opinio juris from these resolutions. So let's use an example from normal life to explain to you how these votes work. If I ask you to meet in a restaurant to mark the end, hopefully, of the current pandemic in December, I could, for instance, suggest 2 different places, and I could ask you to vote. And probably we will decide this by simple majority, which means whoever has more votes, whatever possibility option you have decided with more votes, will win. So we can have bar number 1 with 2 votes, bar number 2 with 2 votes, bar number 3 with 3 votes, and in a class of 7, so we'll have 2, 2, and 3, or even some abstentions. The option that wins is the one we have voted the most. When we talk about absolute majority, we actually talk about the majority, the half, 50% plus 1, it's an absolute majority. So the majority of those who are voting should vote in favor of a particular place, and if we want unanimity, everybody should vote in favor of a particular option. But consensus is different. Consensus will be that I say, oh, let's all meet in Starbucks, and nobody speaks against it, which doesn't mean that those who haven't talked against it are in favor, just that they don't want to contradict the decision. So many of the decisions at international level within international organizations are adopted in this way. Also, many of the decisions that are not binding by themselves and have been adopted within international organizations, such as resolutions of the General Assembly of the United Nations, they might not be binding by themselves. However, they might be an articulation, and we will see examples of this when we look into self-determination. They can be an articulation of customary law that's already there, or it can be that they are helping consolidate customary law, or it can be that just the fact that they exist means that the states will start behaving in a way that follows that that set of rules, even if they know they are not binding. So examples are the United Nations Declaration on Minority Rights, the United Nations Declarations on the Rights of Indigenous Peoples. Many standards that exist in the field of human rights and business are not binding to states. However, states tend not only to behave according to these rules, but other states and other organizations will monitor if they are behaving according to these rules. So in practice, they work a lot like rules, even if breaching them doesn't mean they have breached international law, but their mere existence will change the behavior of states. It's what we call soft law. Some international organizations or some organs within an international organization do have the power to create obligations on states. So, for instance, I said the General Assembly cannot create obligations on states. However, the Security Council of the United Nations, according to Article 25 of the United Nations Charter, can approve decisions that other states must follow, or they will be breaching international law. The same is true for the European Union, that can approve a range of regulations that are compulsory for their state members, decisions of the World Trade Organization settlement of dispute mechanisms, and decisions of other tribunals are also binding for states and also for international organizations sometimes, and even for individuals in exceptional cases. Recently, many have been talking about something as not so well known before, the International Health Regulations of 2005, to which 196 states are parties, that are a set of obligations for states in the case of a pandemic, in a case of a danger, a threat to health that can cross boundaries worldwide. Okay, so this also proves that other organizations such as the World Health Organization can adopt measures that are binding for states. Finally, Article 38 of the Statute of the International Court of Justice mentions judicial decisions and academic writings. These are not sources of international law by themselves. States will not be breaching international law just because they behave contrary to what a very, very important academic thinks, or because they behave in a way that's contrary to what seems to be a final decision of a particular tribunal. You need to find another source, a real source of international law, to talk about a breach of international law. However, still they are influential, they are used to interpret the behavior of states, and they do have an influence on how international law is conceived and applied. They are a bit problematic because when they are used to reinforce arguments or to settle a dispute, it becomes apparent that the judges, the name of the judges and the name of the academics that are used are normally very few white male with the same background, and therefore there is a tendency to limit the use of this kind of writings as supporting decisions. Among the academic writings and among the decisions that have a weight on how we apply international law and how states behave, obviously some bodies have a bigger weight than others. So the International Court of Justice case law will have a particular weight among international tribunals, and also, for instance, the International Law Commission, which is an organ of experts of the United Nations that helps states in codifying new rules of international law or in clarifying which are the rules of international law, will also have a much bigger impact on the final shape of other sources of international law than, let's say, the writings of an academic in a book.